in the landmark judgment of Radhika Agarwal versus Union of India, Criminal Procedure Code or Bharatiya Nagarik Suraksha Sanhita is applicable to GST Act and Customs Act. The dictum as held in Arvind Kejriwal's case that the arrest under the Prevention of Money Laundering Act must be made. How the power of arrest has to be exercised is the question. First question of law that is decided by the Supreme Court as part of the Radhika Agarwal's case. An observation provided by the Supreme Court as part of the Radhika Agarwal's judgment, because most of the GST officers, when they come, they don't even show their identity card. My dear friends, today in Supreme Court, in the landmark judgment of Radhika Agarwal versus Union of India and others, WPCRL number 336/2018 and connected matters, it was held that Criminal Procedure Code or Bharatiya Nagarik Suraksha Sanhita is applicable to GST Act and Customs Act. My dear friends, the dictum, in fact, the court held that the Code of Criminal Procedure, that is now Bharatiya Nagarik Suraksha Sanhita, on the rights of accused persons are equally applicable even under the Customs Act and the GST Act. In this judgment, they also held that the dictum as held in Arvind Kejriwal's case that the arrest under the Prevention of Money Laundering Act must be made only when there is a necessity of arrest, that too based on reason to believe, that too when there is a reason to believe, has also been applied in the context of GST as well as Customs Act. My dear friends, as per section 19 subsection 1 of the Prevention of Money Laundering Act 2002 and section 104 of the Customs Act are virtually the same. If you compare both the acts, that is section 19 subsection 1 of the Prevention of Money Laundering Act and section 104 of the Customs Act 1962, you see similar provisions are placed in both the acts, and the court noted that both provisions deal with the power of arrest. Now this power of arrest, how the power of arrest has to be exercised is the question. My dear friends, similar provision is also there under the GST. The court also observed that there is a arrest provision under the GST Act as well. Court also held that circulars issued by the GST department regarding arrest must be strictly adhered to. Very important point of observation. My dear friends, you see many arrests happening under the GST, and department keeps issuing circulars with respect to arrest procedure. And when department issues circulars with respect to arrest procedure, the Supreme Court today has observed and said that the arrest procedure as provided as part of the circular has to be adhered to. And not only that, court also rejected the argument that customs officers are police officers. In fact, many of the times when the people argue under the Prevention of Money Laundering Act or the Customs Act or the GST Act, they say customs officer or the GST officer or the enforcement directorate or not the police officer. In fact, all these officers are provided more powers than the police officer. So they can never be equated with the police officer. Accordingly, one of the important observation of the Radhika Agarwal's judgment is first question of law that is decided by the Supreme Court as part of the Radhika Agarwal's case is whether anticipatory bail provisions are applicable to GST Act and the Customs Act. The point to be noted here, it is held that CRPC procedure or now Bharatiya Nagarik Suraksha Sanhita BNSS is applicable to GST Act as well as Customs Act. While dealing with this matter, Supreme Court has said that as the CRPC and Bharatiya Nagarik Suraksha Sanhita is applicable, the anticipatory bail provisions, even though may not be provided under the GST law, at any point of time the GST law cannot provide for the bail provisions, then in that situation, the law that is declared by the Supreme Court today is that the anticipatory bail provisions are applicable to GST and even to the Customs Act. My dear friends, this judgment was awaited. More than 239 petitioners were there as part of the batch of hearings that happened today. That is Radhika Agarwal, as we call it as Radhika Agarwal judgment of the Supreme Court, as part of the writ petition. Accordingly, very important point to be noted, the court also observed that there are some merit in the allegations of coercion and harassment by the tax official. So there is an observation provided by the Supreme Court as part of the Radhika Agarwal's judgment where they have said there is a merit in the allegations of coercion and harassment by the tax officials. So accordingly, I quote the exact words of the Supreme Court as part of the observation of the judgment. I quote the exact words. We have commented on the basis of data with regard to allegations that there was force and coercion in the payment of taxes. We have some said that there may be some merit in it. Whenever a person is disposed to pay, he can go to the writ court and get an order, and the officer will have to be dealt with departmentally also. We have said that this cannot be permitted. This is contrary to the law. We have referred to Nandini Sathapathi's case in this regard, said the Chief Justice of India, Sanjeev Khanna, while pronouncing the verdict. The second important question of law that they have decided with respect to the GST and customs as part of Radhika Agarwal judgment that was pronounced today, the judgment stated, very important point, again I quote the exact words of the judgment. The judgment said, in 2009, the Parliament amended the Code of Criminal Procedure to incorporate Section 41B, which outlines the procedures of arrest and the duties of the officer making the arrest. Although this section refers to the police officer, we believe, the Supreme Court has said and declared saying today, that we believe it equally imposes a duty on the customs officer. Even though customs officers are not equal to the police officer, still it is equally imposed a duty on the customs officer. My dear friends, and one more observation is that officers making an arrest are required to bear an accurate, legible and clear indication of their names to facilitate ease of identification by the arrestee. Very important, because most of the GST officers, when they come, they don't even show their identity card. They say they are the GST officers. So there is a requirement, there is a mandate today provided by the Supreme Court to say that the GST officers or the customs officers, or even in case of the enforcement directorate, it is important that the ID cards has to be shown by the arrestee. These provisions are in furtherance of the dictum of this court in D.K. Basu. My dear friends, it is also observed the Central Board of Excise and Customs in circular dated 2012-1998, file number 591/01/98 Customs, referred the decision in D.K. Basu. They have reproduced the relevant portion of the judgment with the intent that these could be complied by the customs officer. We trust that the customs officers shall duly comply with this mandate. Further, the court also mandated that Section 41D of CRPC is also applicable to the Customs Act. My dear friends, one more important observation that has been made with respect to applicability of the CRPC is that reference was made to Section 50 capital A of the CRPC and equivalent section of the Bharatiya Nagarik Suraksha Sanhita, which states that every police officer or other person making an arrest under the code shall forthwith give information regarding such arrest. Information with respect to arrest has to be provided, and place where the arrested person is being held to any of his friends or relatives or other person as may be disclosed or nominated by the arrested person for the purpose of giving such information. My dear friends, the court held that this has to be followed by customs officials as well. By the way, my dear friends, the court also held Section 55A inserted in 2009 states that it shall be the duty of the person having custody of the accused to take reasonable care of their health and safety. This provision shall be equally applicable to the arrest under the Customs Act. My dear friends, while they were dealing about the Customs Act, they also made parallelly an observation with respect to the GST Act. The court further observed that to a large extent, very important, I quote the exact words of the Supreme Court, to a large extent, our reasoning and the ratio on the applicability of the code to the Customs Act would equally apply to the GST Acts in the new section 4 and 5 of the code. My dear friends, it is also highlighted by the Supreme Court. We would therefore agree with the contention that the GST Acts are not complete code when it comes to the provisions of search and seizure. So they have made it very clearly and categorically that the GST Act is not a complete code with respect to the search and seizure. And for the provision of the code, a complete code for the provision of the code, that is which code? CRPC or Bharatiya Nagarik Suraksha Sanhita, equally apply when they are not expressly or impliedly excluded by the provisions of the GST Act. So the point to be noted here, the point of interpretation, unquote, the point of interpretation with this observation is that, let's assume under the GST Act, if a matter is not expressly provided with respect to arrest procedure or search or seizure, then what will apply is the CRPC or equivalent Bharatiya Nagarik Suraksha Sanhita. Accordingly, The point to be noted here is GST search and seizure or GST arrest or even GST bail has to be read along with Bharatiya Nagarik Suraksha Sanhita, my dear friends. My dear friends, the very important point of observation, yet another important point of observation made in this judgment is that since the provisions of the PMLA and the Customs Act dealing with the arrest are similar in nature, the court held that in its judgment in Arvind Kejriwal's case, arrest under the PMLA must be carried out only if there are reason to believe that the accused was guilty and that such reasons must be furnished to the arrestee or applicable to the Customs Act as well. Arvind Kejriwal judgment which is pronounced with respect to the PMLA is now even made applicable to Customs Act because similar provision exists under the PMLA as well. My dear friends, the judgment also had an elaborate discussion about the anticipatory bail provisions. The question here comes, when is the anticipatory bail is applied? Only when the FIR is filed, with the FIR you go to the anticipatory bail. Many of the courts have asked for the FIR before even granting the anticipatory bail. But with this judgment of Radhika Agrawal, which is the landmark judgment in the Supreme Court today, with the Radhika Agrawal judgment that came today in the Supreme Court, what we can understand is that even without an FIR, you can still go and apply for anticipatory bail. It is not when you are getting arrested that you apply for the anticipatory bail. When you are apprehending arrest, that's very important point to be noted. When you are apprehending arrest, then you seek the protection of the court. So my dear friends, based on the facts, generally which are not vague or general allegation, should be considered by the court to evaluate the threat of apprehension and its gravity of seriousness is very important. Accordingly, when dealing with the matter considering the anticipatory bail arguments, I quote the exact words of the Supreme Court, we also wish to clarify that the power to grant anticipatory bail arises when there is an apprehension of arrest. Point number one. It is not essential that the application for anticipatory bail should be moved only after the FIR is filed, as long as facts are clear and there is a reasonable basis for apprehending arrest. So, it is the responsibility of the petitioner while applying for the anticipatory bail under the GST or the Customs or the PMLA to show in these cases, that is with respect to GST, Customs as well as PMLA, generally FIR will won't be there. It is a departmental arrest. It is mostly the judicial custody that they take because Customs officers or Enforcement Directorate or even GST officers are not police officers, then they don't have the power to file FIR. In those cases, if you have a reasonable basis for apprehending arrest, then the principle was confirmed recently by the constitutional bench of the 5 judges of this court in Sushila Agarwal and others versus state, that is NCT of Delhi and another. Some decision of this court in the context of the GST Act which are contrary to the officer ratio should be treated as binding. So accordingly, Sushila Agarwal and others versus state, that is NCT of Delhi, should be squarely made applicable even to the GST Act. My dear friends, court also observed that the anticipatory bail provision was made applicable for offences under the Customs Act as well. So the registration of a case and entries of a case diary are not compulsory when entertaining an application for grant of anticipatory bail under section 438 or 439 of the code, that is the CRPC. Now, the equivalent provisions under the Bharatiya Nagarik Suraksha Sanhita. Accordingly, relying on the decision of the Directorate of Enforcement as Deepak Mahajan 1994 case, what we can understand is that there is no requirement or there cannot be an FIR at all with respect to matters concerning Customs Act or the GST Act or the PMLA, and accordingly, anticipatory bail when you are applying, as per section 438 and 439 of the Criminal Procedure Code 1973 or Bharatiya Nagarik Suraksha Sanhita which has come up in 2023, there is no need to have FIR for applying for the anticipatory bail. My dear friends, this is a very, very important constitutional bench judgment. By the way, even in case of where it involves FIR, if you have a factual and reasonable basis for apprehending arrest, if you are able to demonstrate to the court, still anticipatory bail can be provided. Ultimately, it is the power of the court to decide. My dear friends, Radhika Agrawal judgment which came in Supreme Court today, which is declared by the Supreme Court today, is a very, very important and landmark judgment. In the series of videos, we will definitely understand, because I also was witnessing to this judgment today in the Supreme Court. I can see that this judgment has a far-reaching implication on the GST law, customs law, even under the Prevention of Money Laundering Act 2002. By the way, judgment of Arvind Kejriwal with respect to the PMLA is made applicable even to the Customs Act and the GST Act. We'll see more about this judgment in the days to come. Thank you. Signing off, Advocate Dr. M. Sathya Kumar.